Video is for the jury that was participating in Tarrant County versus Caroline Rodriguez on June 16th through 17th. It was actually a charge of hindrance of a public meeting by disorderly conduct. If you were on this jury or you know somebody who is on this jury, please send them a copy of this video. It's very important to me because this is what I want them to know. This is Lloyd Wetzel. He's an assistant DA for Tarrant County, and he was the guy that was trying to put me in jail. I want these jurors to know that I'm suing him for defamation and slander. And it was for something that he said to the jurors. After the trial is completely over, the judge will ask the jury to stay for just a few minutes so that the lawyers and the district attorneys can ask them how they came to their decisions. It was during this meeting that the district attorney said something so outrageous about me, I can't let it go. But first, my lawyer wanted to know, why did they find me guilty? And they said it was a difficult decision, but this is why. They said it was hard because they could not consider free speech and that the instructions were not clearly written. It was also what was not included in the trial that made their decision so difficult. Primarily, all the overrulings that happened, everything got overruled, and we had limited witness participation. For example, this is Tim O'Hare. He's the commissioner court judge that said, "Get her out of here," and he threw me out of the meeting. We subpoenaed him for my trial. However, the judge squashed the subpoena because the district attorney argued that we were just going to call him to embarrass him. Where's the legal precedent for that? Here's another example of how our witnesses were limited. Somehow, Lloyd Wetzel was able to convince the judge to make sure that nobody talked about free speech during this entire trial. Free speech was off limits, so any questions about free speech would automatically be objected to. Also, C.J. Grisham was not allowed to answer any legal questions, despite him being a lawyer. But we were able to use C.J. Grisham's speech as a comparison to mine. And here's that speech right here.
We have Charles Hermes.
Yeah, right there. Yeah.
All right. So I came here last time because my good friend Mason Yancey was murdered in the jail. All right. That's why I meant to come here, but you didn't hear from me. The reason you didn't hear from me is because the thugs you have outside the door there assaulted me, threw me in handcuffs for no reason whatsoever, and tried to arrest me. Thankfully, Sheriff Wayborn thought the better of valor and listened to me when I told him to read the fucking law. Now,
Remove him immediately for that comment. Get him out of here.
excuse me, that's protected speech.
Yeah, it's not going to be protected in this courtroom.
If it's protected speech. Ridiculous.
This is the problem right here. Let me get my stuff. What the hell's wrong with you people? You're in my way. Let me get my stuff. And Chief Driscoll here needs to be fired.
Mr. Cradaville, is it indeed protected speech?
Yes, it is. I've got the case law right here.
Notice how C.J. Grisham is still in the meeting room. And now Elisa Simmons is going to ask
Mr.
their
Cradaville.
lawyer that's assigned to the commissioner court, whether this is free speech or not. And listen to what he has to say.
Would be appropriate for me to give legal advice and close on that.
I'm sorry.
I would.
I think it's protected speech.
Well, I believe our policy says you don't allow it.
What
The one
policy?
we just passed and the one before it. So, Mr. Hermes is not present.
What did you just say? What? In response to my question? I couldn't hear you.
It's a more nuanced question than simply me making a ball or strike call at this moment. I would say that so long as the action is in compliance with the court's policy, that's what we should defer to at the moment.
So the court's policy supersedes freedom of speech?
No.
Constitution? Okay. But you'll look into it.
I can give you an answer to that question. Yes, it's dependent on the facts of what's occurred. Yes.
So there you go. Their own lawyer confirmed that the F word is protected speech and that the rules of decorum do not trump the Constitution. Then there's a matter of Chief Officer Driscoll. Chief Disco got up on the stand and told several lies. One of them was this. He said that I gave the order for her to be arrested for hindering of a public meeting. Really? Then my lawyer asked him, well, had she said on her way out, have a good morning, would you have arrested her for that? And he said, no, I wouldn't have arrested her for that. So this does come down to a free speech issue,
Words as a matter of law
right?
are not fighting words, and that's Johnson versus Campbell. So your rules of decorum policy cannot trump the laws of the United States of America. So your rules of decorum are setting your county up for liability. We have the right to say, shit, damn,
Remove her
bitch.
immediately.
We have the right to say all these words because it's a First Amendment right, and you can't do anything about it. In the Stillman case,
Oh yeah, and the jury wasn't allowed to see this video. They didn't even know it existed. How could he order me arrested for hindering when no hindering has happened yet? It's the first time I'm understanding I'm under arrest. This is Deputy George, and he says you're under arrest for disorderly. This is before any of the hindering supposedly, allegedly, happened. Do you see Officer Disco anywhere? They can't arrest me for that. They can't arrest me for that. Excuse me.
Take for disorderly.
They can't arrest me for disorderly. You can't arrest me for disorderly. It's not against the law. Unfortunately, I was a little bit loud when I was insisting that my rights not be violated. Let's see how long that I was supposedly hindering.
Sir, out of the way.
Stop pushing me, you're assaulting me. You're assaulting me.
So according to the prosecutor, even though I wasn't in the meeting but in the hallway, I still hindered the proceedings by my conduct, and it had nothing to do with the freedom of speech. But this loudness on my part was only for 17 seconds. Is 17 seconds enough to hinder a meeting and have a year in jail like what he was asking for? Meanwhile, the meeting went on as planned, with the next speaker taking the podium.
Prior to the 2024 election,
Then, Elisa Simmons, one of the county commissioners, was called to the witness stand. She was asked by my lawyer, was there any hindrance at this meeting? And Elisa Simmons says no, there was no hindrance at this meeting. She actually turned to the jury and repeated herself, there was no hindrance. How in the world did the jury still find me guilty after a commissioner said there was no hindrance? And that comes back to what the jury was told to do in their instructions and the fact that they could not bring any free speech into the mix. Now let's get back to that defamation and slander thing. Remember that meeting that the jurors stayed for? The one where the lawyers were able to ask them what made them come to that decision or how was their thinking about this or that? Lloyd went to that meeting extremely angry and upset. And the reason why Lloyd was so angry and upset was that he had pushed super hard for me to get a year in jail. He told the jurors that giving me a year in jail would send a message and everyone would know that cussing out the commissioners is not allowed. And he also said that everybody needed a break from me, including the judge. He also said that cops need to do their jobs without someone over their shoulders filming them. He said there's a pattern, that I was getting worse. And he also told them that if they did not give me a year in jail, that would mean that they agree with my shenanigans and they agree with my type of behavior. My behavior isn't that bad at all, especially compared to Lloyd Wetzel. Lloyd Wetzel was allowed to bring a kangaroo to court every single day, and nobody said anything about that to him. During that 1 year speech, I noticed that all the investigators from the DA's office came to hear it, and they were congratulating each other and looking over at me, elated that I was going away. Then they came back with probation. I was so glad I was not going away for a whole year. Now, back to the jury meeting. These jurors had worked very hard for 2 days and they had taken their job seriously, but Lloyd was mad about my sentence. He was really mad about that probation. So he wanted these jurors to believe that they had made the wrong decision because they didn't have all the information they needed. He wanted them to think that I was a bad character and that I had bad morals. And that's when he did it. He told those jurors that what they did not know was that I quit my teaching job before I got fired because I was having an inappropriate relationship with a kid. That was a lie. They don't let people like that just get away and quit their job. Why was I not arrested? And where are all these kids I supposedly abused? Where are their parents? Why aren't they coming onto my live streams and complaining about it or commenting on my comment sections? Would I be able to have a valid teaching certificate if I had inappropriate relations with children? I don't think so. What Lloyd Wetzel said to those jurors definitely fits the slander elements. He did it to ruin my reputation, he did it with malice, and it makes no sense as to why, except for the fact that Lloyd Wetzel, not only did you hurt me, but you hurt those jurors and tried to make them feel bad about their decision. That's not fair to them whatsoever. That just makes you look like a sore loser, and that's what it was. Sore loser. So again, if anybody knows this jury, anybody from the jury, if you know them, please pass this video on to them. I don't want them to feel bad about their decision they made. Thanks for watching, everybody.